Can you get a hearing within the same month of being arrested? Yes, you can. Doesn't mean the hearing will actually happen. An example is, well, the police station is next door to the courthouse, so. Waiting for the sirens. Oh, as I was saying, an example is from here at Cessnock Local Court. It's alleged the defendant choked his ex-partner. Police have charged the defendant with domestic violence assault, which he has pled not guilty to. There is also an AVO protecting the defendant's ex-partner, which the defendant has agreed to a final order being made. The defendant was charged in early October 2024. He is bail refused and has been in custody since the arrest. 3 weeks, 3 days after the arrest, a hearing is listed at Cessnock Local Court. Yes, 3 weeks later, not the usual 4 to 6 months later. On this day in late October 2024, the truck has already arrived when court starts, meaning the defendant is sitting in the cells next door at Cessnock Police Station waiting for the case to be heard. About 15 minutes after court starts, a call is made to bring the defendant over from the police station next door. Entering via a side door, the sheriff and the Cessnock police officers lead him into the dock. He is dressed in prison greens. He isn't cuffed as he has an injured arm. He sees his family in the gallery before he disappears into the dock. Right from the beginning, everyone involved isn't sure how this got listed for a hearing so quickly. The magistrate describes the situation as extraordinarily odd. There are a couple of issues. First, the complainant, the alleged victim, is here and is prepared to be the prosecution's witness. The issue is police haven't been able to obtain a witness statement from the complainant yet. Second issue is there's some sort of problem with the sound quality with one of the pieces of the evidence. I'm not sure what the problem is because I can't actually hear what they're saying about the sound quality of the evidence from the gallery. The third issue is the defendant hasn't been served with a brief of evidence, meaning he hasn't had the opportunity to see what evidence the police are going to use to prove the elements of the offence. This is important this happens before the hearing because the defendant may want to change their plea or choose a particular defence strategy. They are to be given the opportunity to see the evidence and get legal advice. Not having the opportunity to see the evidence is the main reason the magistrate bases their decision to grant an adjournment. The magistrate explains to proceed with the hearing on this day is unfair to the defendant. In the interests of justice, the magistrate adjourns the hearing until February 2025 and orders the brief of evidence to be served on the defendant. Before the defendant is returned back to jail, he applies for bail, which the court grants. The defendant is led back to the police station next door where his release is all sorted out. We never discover why the hearing was listed so soon after the arrest. However, extraordinarily odd things happen here at the New South Wales Local Court all the time.